Hello, welcome to the eDiscovery channel. We're recording live today from the Marx Brothers Memorial Soundstage at Craig's Ball's home in the Irish Channel of fairly soggy New Orleans afternoon. So it's actually welcome since it's lowered the temperature and the humidity. And it's actually, I hate to say it, comfortable out there. But we've got a couple of topics that we want to discuss. The first of which is, what's that you're holding in your lap, Craig?
This is part of the features of the new studio. As Tom has not mentioned, but we are actually under significant theatrical lightings, and we are mic'd and so forth. Notice Tom actually has a lavalier microphone doing my bit. We are going uptown, quite literally.
Is that a Cajun phrase, lavalier?
Lavalier, yeah.
Is that like a Boudreaux?
It's like namaste.
Namaste.
You gonna evacuate for the storm, Tom?
Namaste. Oh,
what shall we talk about today?
It's a good thing we laugh at each other's jokes, because I'm sure everybody else out there is going, what are these bozos doing?
True that.
So, here we go. Let's seriously, put all seriousness aside, as Mr. Allen used to say. Couple of things we wanted to talk about. First and foremost, we'll get the serious one out, because we're going to get, I think, a little more comical under topic numero 20. And that is, I saw it lying here someplace. Yeah, here we go. Craig, you wrote a wonderful paper and did a webinar recently, as I recall, called Drafting Digital Forensics Examination Protocols.
Wait for the film, folks. I sold the movie rights.
Yeah. I understand it'll be on Netflix next month.
Woody Harrelson will be in it. He's in everything.
At 4 a.m. Which, of course, leads to the next question I have is, did we need a digital forensics examination protocol, Craig?
Tom, that's almost a metaphysical question here. Yes, I will say, whether you get it from me or you get it from someone else, we desperately need a short course and some useful references based on experience and training for lawyers about how to draft computer forensic examination protocols. Now, that's a highfalutin. I managed to get several $2 words into that title. So, shall we talk about what it is, Tom?
Well, no. First, let's answer the musical question.
Yes.
Why? You say we need one. Why?
Because lawyers are doing a rather poor job at this.
I knew we'd get to the heart of the matter.
I'm sorry. You know, one of these days, Tom, I'd love to give a seminar where, Tom, I want to say just how pleased I am with how lawyers have not only met their minimum expectations, but they've exceeded them.
Soared beyond it, yeah.
Yeah, let's just bury me at that point, Tom. I've completely lost it.
Not so much the case in forensics examinations, I take it.
Yeah, and let us say, much, much more excusable for our brethren among the bar not to have a deep understanding of computer forensics. Computer forensics is not e-discovery. It's part of e-discovery, but it is a different animal than e-discovery. In computer forensics, you're not dealing, generally speaking, with documents. You're dealing with fragments, with artifacts, with patterns, with metadata more than objects. So there's much more to be seen in computer forensics, and you have to look at context to a much more significant degree.
Okay, I got to tell everybody now, you got to start worrying, because Craig's getting that serious look on his face.
I'm sorry. You're right. What is there to be serious about in this life? But so this came up to recently in a matter where the parties were interested in examining a machine with a very simple idea in mind, and that was a person using the machine, and if so, what was the person doing on a particular afternoon using the machine? A pretty straightforward, pretty simple in some ways forensic examination. But when the parties were talking about it, the party tendering the machine wanted to put a temporal limit on it, which is to say that you could only look at artifacts, you could only look at items that had dates between this time and that time on a particular range of days.
And I'm sorry to interrupt again. Well,
Not at all.
actually, I'm not sorry to interrupt, or I would have done it. When you say a machine, are we talking about a laptop, a cell phone? What device are we talking about here?
Well, it doesn't matter for purposes of the object here, but in the particular case, it was a laptop computer.
Okay.
But the same could be said of a server,
Okay.
of a phone, an external hard disk drive for storage. All of these things are thought by lawyers, perhaps by virtue of either their personal experience with these devices or by virtue of their e-discovery experience, that these things are documents and files. You can take the metadata values, the so-called MAC dates, modified access or created dates for these files, and only look at those files with those dates in order to rein in the examiner in terms of what he or she looks at. Nothing could be further from the truth in forensics. That is a bit of a crapshoot in e-discovery, depending upon the date that you choose. You certainly want to avoid a last access date because it's not updated anymore. You want, in my opinion, to be careful about use of created dates, because created doesn't mean authored necessarily in the world of Windows, and created dates are easily changed by such things as copying. So the last modified date is the most reliable date for human intervention. But throw all of that out the window when it comes to forensics. In forensics, Tom, we're looking at artifacts that typically have been stripped of their metadata, or we're looking at artifacts that are in compound files, in log files, where the information that contains the date information that's relevant may be held in a file that has an entirely different set of dates that either show a creation date before the time you're allowed to look, or because it continued to be in use, will have a last modified date after the time you're allowed to look, even though the log holds the very information for the very times you're supposed to be looking at.
And would that information have the dates you're looking for?
Could very well. I mean, the nature of a log file is it's recording certain activities or other information for a range of times, usually in a sequence. So if a log file comes to be created on, let's say, January 1st of 2015, and the machine is removed from service on September 1st of 2018, if the dates that are of interest, and that the only ones you're supposed to look at are, say, the 1st of December to the 15th of December of 2017, that information may be in that log, but all of the dates on the file, either the beginning dates for the file that contains the information or the ending dates for the file, will fall outside the period. So filtering by date is going to block you from seeing the very information that answers the questions that the lawyers may want answered.
So what do you suggest? What does your proposed protocol do to address these issues?
Well, for one thing, you don't place limits temporally on the scope of the search by a forensic examiner. We look in an area of the computer, at least historically, we've looked in an area of the computer on electromagnetic drives called the unallocated clusters, or if you prefer, the free clusters. These are parts of the drive, so-called clusters, that have either never been used or have been used in the past and have been recycled, turned back for new storage. It's in these recycled clusters that we have historically been able to bring deleted data back from the dead. Now, that data is frequently missing its metadata values, its modified access or created values, and as a consequence of that, trying to limit me to not look at things that don't have dates is a problem. So what I would recommend, and what I recommended in the article, is don't limit the examiner in terms of the examiner's search by date. Instead, instruct the examiner that to the extent the examiner can assess whether the artifact falls within the focal period or not, the examiner should produce it or not produce it, and that those things that are uncertain but appear relevant should probably be produced to the responding party, the party who's tendered the machine. And if they believe that they are either not relevant or that they are not responsive or privileged, that they'll be able to withhold them and log them. But my point is, don't ask me as an examiner to limit the search based on temporal or time information that I either don't have or is unreliable, let me try to apply those limitations, if at all, after I've located the information and can attempt to perhaps analyze internal metadata values to gain some understanding of what times apply to those artifacts.
Gotcha. What else in the protocol? What other factors?
Well, let's step back on this for a moment. I'm going to make you counsel in the case.
Okay.
And I'll be counsel without any particularized knowledge of forensics. Now, we have an argument, say, over, let's say, a machine that a former employee of yours took to my client's new employer, right? And the allegation is that your client took information,
Privileged information, trade secret, something that he could use at his new employment to better himself.
So I've lost track. Who's got the thief here? The alleged thief.
I was going to say alleged thief.
Alleged thief. All right, I'll tell you what. I'll have the alleged thief. I'll let you be the good guy here. So you're the aggrieved employer's lawyer. You've lost a laptop. That laptop's come to my client, who is the new employer. And let's say I've resolved conflicts and I represent both the former employee and the new employer. Now, you want to look at the employee's computer.
No, it's my computer. I want it back.
Well, let's just say it was, let's make it easier. Let's say it belonged to...
It was a BYOB.
So bring
situation.
your own device, or let's make it more classic. This is a device that the former employer brought onto the premises the night before his departure. And the allegation is he connected it to the work
drive,
computer.
A thumb drive, a portable hard drive.
Sure, whatever you want to make it. And the point is that you want to see what's on that machine, and you want to see, importantly, what that machine might have connected to subsequently and how that data might have been used. Now, let's assume that some deletion has gone on here, so some forensics may be needed to get to the bottom of this. Now, the first thing you're going to ask for, presumably, is, Judge, give me the other side's computer.
Yeah.
Yeah, well, that's not right. I mean, that's rarely right. I mean, at this point, they're going to be privileged attorney-client communications. There may be work for a competitor that's been done subsequently. There are any number of reasons why you don't have
Fruit of the poisonous tree.
Well,
he wouldn't have done anything if he hadn't stolen from me. An emotional denoberation.
An emotional denoberation? What is a denoberation?
It's a boilerplate objection that I've thrown in there. We'll circle back to that point later.
Well,
I'm planting a little seed.
Tom has been denobbed, apparently. That would make me upset too, Tom. So, emotional denoberation. All right, so...
See, one of the first tricks of a good litigator is to get the other side off balance. It's kind of like boxing, right? You switch from a righty to a lefty stance just to take him off his game, which apparently I've successly accomplished here.
You've rope-a-doped.
That's right.
Sure.
The old rope-a-dope. And who better to do a rope-a-dope than me? I got the dope going.
I'm glad you said it. I wasn't going to say it.
So where was I?
The point is that there are
I'm not going to get the whole
good
device.
reasons why I'm going to fight turning over my client's computer to you. I mean, but look, an examination has to be made. And so, I say, okay, we're going to have somebody examine the machine. Give us some keywords.
And I'm going to say, I'm not going to let you do the examination. I want an independent examiner like that world famous Craig Ball to come in and look at this thing and do a report.
Or even somebody good.
Well, I see Craig Ball all over the internet, so I assume he's good. So I'm going with him.
Yeah, I see the guy who sells Fort George Foreman grills all over the... Never mind. Let's not go there. So... Now,
independent. I'm not going to leave the examination and the report to you.
Oh, so now we have to agree upon an independent examiner.
Yes.
I want my guy.
I want a guy. If we have to go to the court, we'll go to the court.
Right,
we should be able to solve it.
I want my woman then.
All right. Well, I want my MTV. We're going to the court to get an independent examiner.
Okay, so we need a mechanism for selection of the examiner. If we can't, either we have to agree upon one, or we need to pick our own examiners and have them agree upon one, or we need to have CVs and billing sheets submitted to the court, but we need a mechanism. So there's language in there that goes to the issue of helping the court to select an independent examiner.
Right.
But then we need to tell the examiner what to do.
What the scope is.
Right.
Yeah.
All right. Now we have a mechanism to get an examiner, Tom. Now I'll give me your keyword searches, and we'll submit our keyword searches, or we'll object to yours. Good.
I'm actually pretty good with keyword searches if I have a what we call in our business an SME.
Sadomasochistic what?
No, subject matter expert.
Ah, okay.
We've had I don't want to go down that rabbit hole. In the right circumstances, with the right types of cases, people can agree, I think, on good keyword search. There was a recent decision where, I forget the court, help a brother out here now. There was a decision in California recently where the judge applied some standardized testing principles to a forensic search that was done using only keyword searches.
Was that one with an illusion protocol?
Yes, the illusion protocol.
Yeah, but
Ralph Losey's got a great.
But that's e-discovery.
I understand, but I'm saying
there's very little place in this setting.
I understand, but I'm saying that in some cases, I think keyword search can be helpful. I understand what you're about to say. I think that being
I'm talking about
forensics. Yeah, that we're not talking e-discovery.
No, we're not talking e-discovery. I mean, those keyword searches work pretty well when you have a defined set of documents that are textual. But are you going to use keyword searches against metadata values? Are you going to use keyword searches? No. And that's the thing. You're going to use it against artifacts, patterns of usage, and so forth. In the case I was talking about, the thing we're looking for is what happened using that machine during a particular interval. Keyword searches are just simply going to suck at finding that sort of information. I remember a number of years ago a case out of New York involving allegations by audit associates that they weren't being paid overtime hours. Do you remember that case?
Yeah, sure.
And in that particular case, the proposition was they were going to use keyword searches against hard drives. And I thought to myself, oh my God, they don't have any idea what they're talking about. You're not going to find the information about when people logged onto a machine, stopped working, when they printed certain documents, whether they were within the course and scope of their work or not, by keyword searches. That's an insane way to go about it.
Right.
But the lawyers were so conditioned to e-discovery methodology that nobody seemed to stop to think about, wait, this is a forensics examination. We need to work within the realm of forensics. And keyword searches have a place. But
this isn't it.
This is not that place. If I'm looking for deleted files, I want to use mechanisms to find deleted files.
So it sounds to me like the first reason we need this protocol is something you've just described, which is we in the e-discovery world have been so conditioned to think a certain way and use certain tools, we're misapplying them when it comes to a forensics examination.
I could not have said it any better if I had written it in the paper. Exactly. No, and that's exactly the point, Tom. Thank you very much. We are bringing a little knowledge being a dangerous thing, and the assumptions that we make that all electronic search is the same. Forensics tools go about it a different way. Another thing that I think that's missing is one of the first things you want in an examination protocol is to empower the examiner to assess the integrity of the evidence being tendered for examination. I'll give you an example. Many of the needs for forensic examinations come about as a result of suspects' a suspicion of fraud or of abuse of a machine, bad behavior. So the people you're dealing with may often think that the best approach to it is to alter the evidence, destroy the evidence, delete the evidence, etc. I can't tell you how many times I've had evidence come into my lab and someone has swapped the drive from another machine or has wiped the drive and tried to reinstall the operating system. All
of which is fairly apparent to you on the surface when you first look at it?
Well, at least it's apparent enough for those where I've found it. I guess I've always felt that if the perpetrator is smart enough that there's no way I can figure it out, well, they win.
Yeah.
No, but the answer, of course, is most forensic examiners are pretty adept at being able to assess the integrity of the evidence they get, determine have there been wiping tools used, Has the operating system been changed? Has the file been, the drive been reformatted? A variety of other things that may be done to game it.
So,
and swapping is a good example.
And obviously, from my perspective in the scenario you set up, that's going to be important to me. I am going to want to know that.
Very rarely do I see a forensic examination protocol empower the examiner to opine about whether or not the evidence that's been tendered is legit or not. And that can create a real moral dilemma for the examiner. If I've been told by the court, you may only look at these things and you may only report on these things and nothing else, and I determine that someone has swapped the evidence for, and it's not what it claims to be, I need to be empowered to advise the court and the parties of that.
That's happened, yeah. Okay, so that's definitely something I want. Yes.
Right. And then I need to talk about the scope of the examination. There needs to be some temporal limits to the scope, and again, not imposed upon the examiner in terms of the scope of the search, but in the scope of the deliverables, in my opinion. And I think I have a lot in the paper where I talk about the sorts of artifacts that you may want to address in the protocol. And this is where you need to work with an examiner. Before you start trying to say that the examiner shall do this, it's a wise idea to sit down with a forensic examiner and find out what we can do. And what we can do depends upon the machine, the operating system, the age, the usage, the condition, a variety of other factors, encryption being a big one nowadays, frustrating our abilities to do certain things. So gather up some information about what's going to be examined. Is it a Windows machine? Is it a Mac machine? Is it a fully encrypted disk? Is it a solid state hard drive, an electromagnetic hard drive? How long has the machine been in use? And what's the capacity of the disk? Are we talking about something measured in gigabytes or something measured in terabytes? I had a call yesterday asking me about doing a forensic examination of an energy company before October the 1st. We're recording this in the end of the first week in September. So 3 weeks. And I asked about, how many machines, will it be servers, etc. The lawyer had no information about the scope. Now, he wanted us to know not only how long is it going to take, but what it's going to cost. And so how do you tell somebody what it's going to cost to examine an unknown volume of data from an unknown volume of machines running an unknown variety of operating systems and in use for an unknown period of time? And that's like, I have something outside the house. How big is it and what does it cost? Well, I don't know. That's ridiculous.
There's something out there.
Yes, there is.
Something on the wing.
Yes. Yeah. Okay. Next question, Tom.
Well, and this wouldn't be one that I would ask, I would think, but my opponent would be cautious of. If we're going to let you look at everything, how is his privileged data, the data that does not relate to the dispute, the new work that has been done, how is that protected?
Well, that's a very good question. And there are really two approaches to that come immediately to mind. First is I like to have a statement of the goals and the restrictions. What is it we want to happen? What is it we don't want to happen? So a preamble to the forensic examination protocol should say, the examiner has been engaged to address the following issues and to be able to answer the following questions to the best of the examiner's ability. And the examiner is also limited in terms of wanting to take no steps to inadvertently disclose privileged attorney-client communications, attorney work product, confidential trade secrets is a great example, confidential personal behavior with no bearing on the issues.
Right.
I think you want to give the examiner a roadmap for what it is that is aspirational to the examination, so the examiner, in applying the appropriate amount of discretion that you should give the examiner, can work within, this is what the parties are seeking to accomplish, and this is what they don't want to happen as a consequence of this examination. Going to the specifics of privilege, I wrote some exemplar language that describes a mechanism whereby
in this protocol?
In that protocol, in the exemplar protocol and beyond, I provide some language that might be useful, some drafting instructions.
Great. And
that's what I've gotten to. For years, Tom, I've fought the idea of providing forms and drafting stuff. But the reality is that
we need guidance on this.
Lawyers want to start with language.
Yeah.
They're just giving them the principles and inviting them to draft themselves. Lawyers are not taught, I think, in law school or elsewhere, to trust their own drafting capabilities. So they will take a lousy form over a good bespoke drafting effort any day of the week.
Well, especially in this area, I would say, if you were asking for a motion for summary judgment to be drafted on a particular argument, that's one thing. This is an area that's, if not alien to most attorneys, certainly uncomfortable.
That's a fair observation.
Yeah.
And so they need to start with something that helps them. And the purpose of this paper was not just to put out some form language, but to also explain what that language does,
right,
why it's there, and how help lawyers make decisions about whether it's appropriate for their case and what kinds of changes they might want to make to it more suitable for the particular issues they're dealing with. Going back to the issue of privilege, the language that I outline provides for information to be given first. For example, it'll all be logged. There'll be a listing of the objects so that one can keep track of what was there, and then the objects themselves plus the listing are provided to the party with the production responsibility. That gives that party and their counsel the opportunity to make objections, argue that certain things should not be turned over, right, and then failing that, assuming they're deemed relevant and responsive and non-privileged, the balance of the information would be given to the party or to the court, depending upon the nature of what's sought to be accomplished. Probably more likely the party requesting the examination. And that creates a way to balance the legitimate interests of both sides. On the one
right,
hand, protecting against inadvertent disclosure of things that should not be disclosed, and at the other hand, assuring a level playing field and competency in terms of finding the things that most lawyers, even those experienced in e-discovery, would not be capable of identifying and extracting and providing in the form of artifacts, deleted objects, and so
right,
forth, contents of logs.
So at the onset, you, speaking for the one side in this party, offered to do this sort of work yourself with your own expert. Is there really any way to do that to satisfy both sides? Doesn't this entire process beg the need for an independent expert agreed upon by both sides?
Well, when you say this entire process, I would say no. I think there are means of forensic level preservation that can be achieved using IT people following fairly simple mechanisms, using fairly low cost or free tools. So I think forensic level preservation is something that can be done internally at a law firm by good, well-trained IT, etc. When it comes to forensic examination, it's a specialty. I don't think you would expect your GP to be able to do a defensible
right,
autopsy in a dispute, in a case involving a questionable death and so forth. You wouldn't expect them to be able to do forensics. And I think you'll find the same is true when you're working with the artifacts associated with modern operating systems and electronic devices. It is well beyond the ken of even well-trained and experienced IT and network experts. That's a specialty. I would not substitute my expertise for theirs in many instances. Mm-hmm. I would hope they would not feel like just because it's got bits and bytes and it's a computer, that therefore someone who's got computer science can do it. The worst mistake we see in the profession of computer forensics is people who take these weekend courses or online courses, or even worse, just buy a tool and figure forensics is a push button thing. I just push the find the evidence button and now I can hang out my shingle as a forensic examiner. That is a disaster waiting to happen, and I've seen it happen. It's not really waiting to happen. I've seen it happen in a number of cases. Even one involving several high-profile litigation support companies who just figured that somebody could do forensics.
Right.
It's a specialty. It's something you have to keep up with. It's become much, much harder to do forensics today because there's so many more and different things to look at, and we're losing many of the traditional forms of information that we looked to in the past. For example, the so-called carving or resurrection of the contents of these unallocated clusters, a lot of that is going away by the emergence of solid-state drives and full disk encryption and auto overwrite and a number of things that we didn't have just a few years ago.
So, because we have a couple of other topics we want to cover, let me ask you two things. And I'll give you both of them so you can kind of handle them at the same time. One will be the final wrap-up. Is there anything else you want to mention about this area in closing? But before that, we've talked about specific devices. What about data stored in the cloud? Is there anything a forensics examiner brings to the table there? Is there a need if the data that in question has not been stored locally on a device but has been in the cloud? Is there anything that a forensics examiner can do or assist in, or is needed to do or assist in, getting at that information?
I am going to give you a qualified yes, and it is qualified because we're looking at a brave new world when it comes to forensics of content and sources to which you have no access to the so-called back end, where you can't look at the physical media, where you may not be able to look at the infrastructure, the operating system associated with the information. And we'll see that. And it's funny you mentioned this because this came up in a conversation I had with a colleague last night involving Gmail. And the question was whether it was reasonable to demand all the metadata associated with Gmail. Now, my colleague pointed out that I've been harsh when lawyers just say, give me all the metadata. And you say, what metadata? And they go, the metadata. Because that's like saying, give me all the information. By itself, it doesn't mean very much.
Right.
Do you mean the application metadata that's inside the files, in which case you might be asking for native production? Do you mean the system metadata associated with the environment in which the files were stored? In which case, there can be literally hundreds of potential fields of metadata. Why should we go to the trouble to collect them all and produce them all? And if so, how do we produce them? Have you spec'd out a load file? This gets kind of technical. And when all you really may be saying is, I want all the files with their paths, their MD5 values, and their last modified dates and times, okay, now we kind of get a sense of what you're looking for. Now, the Gmail question was interesting because Gmail, of course, is a pure cloud play, assuming no one has downloaded it to an email client like Outlook or something. How do I get the Gmail metadata? Google's not going to let me come out to Mountain View and open up the back of their servers. If you have any sense of how Google is constructed, the architecture of Google, that's kind of even a crazy notion. So the answer is there is metadata. There are unique fields of metadata associated with Gmail messages, and Gmail allows a so-called takeout process, the ability to download virtually every kind of content that Google can hold online for its customers and clients, Gmail among them. The specific Gmail metadata fields that are different from the kinds of metadata fields that we often see with other forms of email are preserved by Google, and when they are pulled down, taken out by the Google takeout process, all of those metadata values are embedded in the so-called mbox format that Google applies for this purpose. So all the Gmail metadata is in there. Many who process Gmail mbox takeouts don't know how to process or present that metadata.
And I'm sorry, but where is that physically? Where's that being stored? Is that in the cloud, or when you do that takeout process, are you designating a local storage space for that?
When you get it, it's in the cloud because it's the metadata used by Google for many purposes, flagging, threading of conversations, and so forth. Because those values, those characteristics, are only made to work within Google's unique system of presentation, the Gmail app, those things may not apply. in fact, don't apply when you, say, move things to a more familiar format like Outlook. But those values exist. They are metadata associated with those messages. And so when you take it out, what Google will do is they will put it in the form of an MBOX. An MBOX is a recognized format for the handing back and forth of electronic mail. And they will add additional fields within their customized MBOX format to hold all those extra metadata values.
Gotcha.
Now, a lot of tools we see today in the discovery marketplace don't know how to deal with those, and virtually none of the tools I've seen have the ability to use that metadata to present Gmail in a way faithful to the way we see it on the web. But that's not the important factor here. The metadata is there. If somebody wants it, it's easy enough to pull it down.
Okay.
It's in there, like the old Prego sauce commercials. It's in there. It's in there. The question becomes, is it necessary? And if you're going to present that information in a format for use by a recipient, a requesting party, how do you present that? How do you hand that information off? And if you're going to use it as a form of production feature, like for threading, you need to understand what you're dealing with. That gets to a different level. But if somebody says, give me all the metadata, it can be done. You can put it in a load file. You can give them a customized MBOX format. Okay. It's not as hard as most people think. Now, is it pointless in some instances? Yeah. A lot of that metadata is not going to translate to the viewers you're going to use to review that email.
Which is why you need a protocol to decide whether you want that.
Now we're in the discovery world, and in the world of e-discovery, you're going to need a protocol. You're going to need a protocol for production. Yep. And I've written extensively on drafting production protocols that deal with those very things about formatting load files, speccing load files, aspects of native versus near native versus near paper formats and so forth. And we don't need to go into that in any depth except to say, if you want to learn more about that, importantly, if you want to learn how to spec that out in your request for productions and negotiate those protocols with your opponents, you could read for a better part of a day on the stuff that I've written on that. And Tom, where would you go to get that stuff?
Where would I go to get that data or that information?
Those articles.
I would go to your website, Craig.
Well, where is that, Tom?
That would be, I don't know, actually. I keep asking this. Is it craigball.com?
craigball.com, yes. craigball.com, all one word. And all those articles and many more, much of them will be on the left side of the page.
And the reason I've always been confused is because you write on a regular basis the Ball in Your Court column. Those columns are archived on craigball.com?
No, those are archived on Ball in Your Court. But of course, there's a link on Ball in Your Court that will take you to craigball.com. And not surprisingly, there's a link on craigball.com that will shuttle you over to Ball in Your Court. Ball in Your Court are short articles generally in the nature of their blog posts. And those are used to address things as the spirit moves me. I've been very busy lately after a long dry spell of not writing very much. For example, I think just 3 days ago, well, you know, when you got to have the time, you know, just Tom. Oh, there are how many fest seasons in our fair town of New Orleans, Tom?
Well, like other parts of the country, there are 4 seasons in New Orleans. They're just slightly different.
What are they?
Well, there's carnival season, hurricane season, crawfish season, and football season.
Absolutely, and we're deep in we're starting football season.
We kind of got the overflow now between hurricane and football. That's a tough one.
Busy time. So I used the hurricane hiatus of the last several days that we've had in anticipating the hurricane that thankfully made landfall nowhere near us to sit down and start writing about them things. I wrote that article and can you show that to the camera? It's called, upside down.
I'm sorry.
Thank you very much. Drafting Digital Forensic Examination Protocols. It's actually in living color when you look at it.
And is this on Ball in Your Court or craigball.com?
Both.
Both. There you go.
If you go to Ball in Your Court, you'll find not only the article in a blog post, but you'll find a link to download a PDF. I'd suggest, unless you want to sit through what would be a 15-page article reading it as a blog post, that you might want to download it. And if you were to go to the website, craigball.com, you'll find it's linked as the second most recent article. Another article that I wrote just in the last 72 hours or so, I don't even remember what I talked about on that one. Tom, you remember? I just blanked here for a moment.
Privilege?
God, I just can't remember. Anyway, I tell you what, so many that I can't even remember the ones from this.
So much information, so little time.
Well, I mean, it's obviously you got to take it with a grain of salt because I wrote it, but I do try very hard to provide useful information, balanced. Even though I may personally take a strong view on one side or the other, I do try to present both sides of the issue so that you can laugh at and discount the opposition I don't happen to agree with.
Well, that's because as a blogger, you are clearly part of the new trend of the new journalist, which gives you access as a viable member of the press to conferences world. Well, that's a different argument. We'll have that discussion another time.
Inside joke, folks.
Go to Kevin O'Keefe's blog this week, and you can find out all you need to know
what
about
that. Your Tech Gumbo?
Techno Gumbo has a few things on it. Kevin's piece that I believe came out yesterday references my article as well as several others. But I want to ask another quick question.
Oh, I know what it was. Pardon me. Excuse me.
Oh, no, I'm sorry.
I wrote about...
Your time has expired. You're not allowed to go back.
Forgive me, please, more, sir, please.
We've switched to the chemistry book. We've put aside the social...
But I remembered what I wrote about.
Teach
and you were there, and you were there, and you were there.
All right, go ahead.
I wrote about protective orders in the context of electronic discovery, particularly the problem we have where people are required to turn back information that has been produced, the issue of how do you turn back electronically produced information, are you required to destroy all of your backups, to clear it out of your old email and so forth. And so I raised and debated those issues because I think they are important issues, particularly if you are listening and you ever serve as an expert in these cases or consultant in these cases. So anyone listening to this...
This question's going to come up. You're going to be asked this question by your client.
If you're an e-discovery expert, if you are a forensic examiner, if you work with an e-discovery company or vendor, service provider, you better take a look at this issue, because the reality of how you give back this information is more challenging. You're going to violate this protective order the way they're customarily drafted, and the only thing keeping all of us from problems associated with that is the fact that everyone seems to be so exhausted at the conclusion of a case that there's very little follow-up on these obligations. But that won't last forever, and we need to do it right. So take a look at this. I provide some language that can go into these orders, very simple language that will serve to preserve the goal of the orders and meet the needs, the legitimate needs of these orders, without tying us all up in knots and forcing us to be dishonest or fail in our later obligations to meet these very important orders.
Great.
Thank you for allowing me to add that, Tom.
That's okay, but you just eliminated all your extra time, so now we have No, so actually, we have a little bit more. We have all the time in the world because we're filming this, so we can take as much time as we want.
But I'm cooking red beans and rice in the other side of the
studio. Well, in that case, we're done. No, I'm going to give you a choice in the immortal words of the Grateful Dead. It's a buck dancer's choice, my friend. You better take my advice. We can talk very briefly about the wonderful blog that I mentioned that I read earlier by Ron Friedmann. I want to make sure I get the title correct, called Innovation Takes More Than Talk. Bold words, my friend. Bold words from a one-eyed fat man. A lot of movie references today. The sound studio has got me in the spirit. Or you can talk briefly about the frustration you expressed earlier at the onset of the discussion here with what's going on in our profession, especially as came to mind in the Belke opinion that you just read.
And we actually did not talk about that in this recording. That was offline.
Well, that's what I said. We talked about it before we came online here.
Let's talk about Ron Friedmann's very pointed complaint, and I want to come back and maybe we'll have
to do another session about Belke.
About how to do meeting and objecting in electronic discovery, because boy, there's a lot of work yet to be done.
Well, Ron was talking about what has become a widespread topic of discussion, especially at conferences these days. He and I were both at ILTACON 18 in, they say DC, I say National Harbor, they say DC, I say Maryland, whatever. It was a great conference, but like many others that I've seen being advertised for the remainder of the fall, innovation and disruption and new technology being used to get better results is a big topic. And as I mentioned, Ron's blog today, the title was Innovation Takes More Than Talk. And what he really said was that despite all of this talk about innovation and disruption and new technologies and new ways to practice, that we don't really have a metric for measuring the quality of attorneys' work. Therefore, how do we measure innovation other than talk about it? Do we have something, and Ron said he didn't feel we did, do we have a metric that will measure this newfound or so-called innovation? So-called is my phrase, not Ron's. And so I, as you mentioned before we started in here, we just happened to casually talk about it a little bit in the kitchen. But your thoughts, just quickly. This, I think, can lead to a much broader discussion later, but because it's being talked about so much, I really thought it deserved at least a couple of comments.
Well, there's so much I'd want to say about different aspects of that. So there are basically three things that come to mind. The first is the issue of metrics. I have a big problem, and I have vented numerous times about how opinions and polling has taken the place of measurement in the world of electronic discovery. We just find it's easier to ask people what they think than aggregate their opinions and call it fact than it is to actually measure. And I think that's a problem. And when you ask people what they think something is going to cost, and then you average their guesses, that's not really scientific. That's an opinion poll. It's something you can measure, and whether it be the cost of certain objects or setting certain metrics, we have the ability to do it. What we don't have is the will or perhaps the time and money, and that's been a problem. But going to Ron's point, we have metrics that we can measure with regard to improved performance of lawyers. Obviously, there is a quality metric that is going to be somewhat amorphous in the standpoint of, are your clients happy? Do they continue to rehire you? Are you being sanctioned by courts? Are you meeting deadlines? There are performance metrics that, while they don't really talk about really how effective an advocate you are or how much you win, perhaps, they at least will provide some sense of you must be getting the job done because people keep hiring you and you're not being pulled up before the bar for professional responsibility challenges. It's, like I say, it's not a very precise metric, but at least think of it as a pass-fail.
Yeah.
So that effort, that ball of effort, if you will, comes at a cost. And it's relatively easy to measure the cost of how long it takes attorneys to do tasks. If there's anything attorneys are adept at, it is turning their time into cost assessments in the form of billing in 1/10 of an hour increments or more. And so what we are really talking about often in innovation is reducing the time to complete certain tasks or the cost of completion of those certain tasks, which is often measured by the reduction of the amount of bodies that need to be thrown at a task to complete it. So in the context of electronic discovery, we often use metrics such as the amount of data processed, the amount of documents reviewed, perhaps a page metric, an eyeball metric. And so we have ways of measuring improved efficiency. Are they good ways? No, but we're not exploiting those that we have, so there's no point in challenging the quality of the metrics that we aren't even bothering to assemble. The third thing goes to a different kind of rant that I'd like to share with you, Tom, and that is in the context of e-discovery.
the innovations we keep hearing about in electronic discovery seem to focus almost exclusively on things that I regard as rather late in the process. Review is the best example. We hear about artificial intelligence, we hear about various forms of technology-assisted review, machine learning, and so forth, and all of this is great and wonderful. But to me, it comes way too late in the process to salvage the things that I'm most concerned with regarding electronic discovery. When parties are focusing on whether to use TAR or predictive coding or other advanced technologies and analytics in the process, they're almost always talking about applying those to the review process, to the lawyer part of the process, lawyer eyes-on part at least. And so much of the failure of electronic discovery that I see has occurred long before. It's occurred in the preservation process. It has occurred horrifically in the collection and filtering, culling process, and in the processing of the data to make it amenable to search. The train is already often so far off the tracks before any of these advanced analytics are ever thought to be brought into the process that I don't view them as the cure-all or the source of excitement that others do. If all you think electronic discovery is lawyer review, and let's face it, that's all most lawyers think of because it's really the only part that they see, and it's the part where they profit the most. Let's face it. If that's all you think e-discovery is, then AI and advanced analytics, blockchain, whatever you want to throw in there. We're not allowed, by law, we're not allowed to have a webcast now without mentioning the blockchain. So, Tom, how's your blockchain?
Yeah, I've shifted it over to an AI interface.
All right. So that's my final rant of this broadcast, which is that we've lost touch with the left side of the EDRM. We didn't fix it. We just got bored and moved on. The problems that we saw years ago are still very much with us today. In fact, I would argue that they are even more with us because the data has moved. The data has gone mobile, gone rogue onto mobile devices,
and
phones.
Increased in volume, exponentially.
Volume and complexity. Yeah. It's shattered into a million shards, and quite literally a million. It's nowadays it's not unusual to have a million objects associated with a single device. So all of this is manageable, but not if we just simply look away. And blockchain is great. And AI is great. These are the shiny new objects that we talk about at e-discovery conferences.
Don't forget innovation.
Innovation. I mean, all of these things have their place.
Disruption. Got to have disruption.
And interruption.
Much as I disrupted you just there, yes.
So look, they all have their place. I'm not saying those are not important or this is important. What I'm saying is garbage in, garbage out. We're not doing a much better job on the collection and identification and preservation and processing of the information, resolving the exceptions, making sense of it before we begin bringing the robots to task. Because the robots are not embedded in the companies. Some would argue, oh yes they are. AI is now important, big data, blah, blah, blah. Say what you will. On the e-discovery business, it's business as usual. We're not doing very much on the left side of the EDRM on the identification, preservation, collection, filtering, and processing parts. We're not doing much more or differently today than we did 15 years ago, 10 years ago, with the exception that we've integrated those processes. We've coupled them more tightly than they used to be coupled, but we're not fundamentally doing that much different. And I'm more than happy to debate anybody in the industry about that and open to being proved wrong about that.
Profession. It's a profession. It's not an industry.
Well, the e-discovery is an industry. Law is a profession. But we can have that. We can have another argument about that.
Yeah. Okay. Quickly, thanks. As you mentioned, we're recording this on the 7th of September. Today's September 7th? September 7th, 6th, something like that.
September 7th.
So we're early in the month of September. Where will you be appearing that someone might partake of your wisdom in person in the next month or so?
Well, you mentioned the webcast I just completed. I wanted to mention that was for ACIDS and our friends at ACIDS. And
Great.
So any of you who are interested in broadening your horizons with regard to e-discovery, ACIDS, the Association of Certified E-Discovery Specialists, I believe is what that means. That's a good place to go for useful information.
Yes, they have quite a library of webinars that they maintain there. So
good people there, and I'm going to be looking forward to a lot of things. I'm going to Portland, Oregon, shortly. For the Preservation Excellence Conference. This is a wonderful conference, the PREX conference.
I'm still waiting for my invitation to that. I probably got lost in the mail.
I'm sure that's the case, Tom. You really should think about getting an email or a computer. I'm going to be doing a couple of things at PREX, and I hope you all will consider attending. One of the things I've been asked to do, which is exciting for me, is to interview Jeffrey Toobin, who I believe is the chief legal correspondent for CNN and also writes frequently for the New Yorker magazine, a magazine that I never miss reading, and also speaking about collection of mobile and cloud, I believe, as well.
Not with Mr. Toobin.
No, I'm not sure what we'll talk about with Mr. Toobin. I'm going to check in with him on Monday, and we'll figure out what he wants to say.
And when is that? You mentioned it's in Portland. When?
That is in Portland in 2 weeks from now.
Okay.
So it's Wednesday, Thursday, and Friday, 2 weeks from now. So that will be, I'm guessing, was that the 13th, 14th, and 15th, something like that?
Yeah,
12th. Anyway, it's the
a couple of weeks in Portland.
In 2 weeks in Portland, but it'll be I want to say it's the week encompassing September. Oh no, that's not right. No, scratch that. It's the 2 weeks from now would be in the 20s. So it's going to be more like 18, 19, 20, somewhere in there. Anyway, go online. Look up the Zapproved, ZAPPROVED, PREX, PREX conference in Portland, and come by. It's a terrific conference. Many, many fine presenters and keynote presenters.
But not me.
But not Tom O'Connor. They're saving Tom probably to like the 10th anniversary, to a really big one. You know, you don't want to bring out the big guns too soon on these things.
Yeah, well said. And any place else? You mentioned some other places, or you have some other places you'll be appearing?
I will be. I'm going to be talking in Texas a couple of times. I honestly, Tom, my schedule is such that I have to go to my website to look at it. If you're interested in the cities where I'll be talking, at craigball.com, in the center top of the page, there's a listing of the dates and cities. I'm going to be doing several presentations, much as you are, I believe, for our own Louisiana State Bar. I'm not a member of the Louisiana State Bar because I'm not licensed in Louisiana.
Nor am I.
But I am.
But they call on us quite frequently, and we're grateful for that.
We are indeed. I'm doing 3 programs in webcasts in New Orleans over the course of the next 2 months, till I think about the end of October. I'm looking forward to doing those as well.
Great. Excellent. craigball.com. Go there for references to everything you've heard here, as well as Craig's speaking schedule. And
Tom, where can they get to Techno Gumbo, your blog?
That would be, Techno Gumbo.
Technogumbo.com?
Technogumbo.com would get you there.
That works for me.
Yeah. So that's it. That's all we have for today from the eDiscovery channel. Thanks for tuning in. We will see you at one of these conferences down the road, or here in the wide, wide world of the internet sometime in the near future.
How about some red beans and rice, Tom?
I'm with you.
All right.
You're right.
All right, we're going for a lagniappe. We'll see you next time.
Thank you, folks.
Bye-bye.